I'm pleased to introduce a final video that we have for you today on the perspectives. So I want to introduce Diane Robinson, PhD. Diane is a Principal Court Research Associate for the National Center for State Courts. Since joining the National Center in 2019, her project work has been focused on data governance, collection, quality, and data sharing. Diane has a focus on guardianship and conservatorships and elder justice issues, among other projects. She has led the Guardianship and Technology project, on which I've also had the privilege to serve. Diane's passion and work ethic have inspired me in this work, and I'm pleased to share some pre-recorded comments from her now.
Hi, I'm Diane Robinson. I'm with the National Center for State Courts, where I work in our research and design group. I've had the privilege of working with a number of states on guardianship improvement projects and also working on a couple of national projects about guardianship improvement. So I wanted to talk a little bit about what's happening. One of the common things that you'll be hearing about over the next couple of days is the need for increased data in guardianship monitoring. Pennsylvania has made great strides with this with the guardianship tracking system, and it's something that we see happening in other states as well. The challenge is that in many jurisdictions, some courts don't even know how many guardianships they have open at their local court. And so getting a statewide or national picture can be really challenging. So we're doing some work in that area. One of the things that we have done is in conjunction with our partners at the National Guardianship Network, including the American Bar Association and the National Disability Rights Network, develop technical and business standards for data collection and guardianship. Amy Whitworth has been a really important part of that project, and I'm pleased that we have published those standards. We'll give you a link to those. They have already been adopted by NACM, the National Association for Court Managers, and are currently under consideration by COSCA, the Conference of State Court Administrators. We believe that having those standards will help us to have case management systems that do a better job of collecting and tracking guardianship data, and will provide some clear expectations to vendors about what it is that courts need for these cases that where courts have responsibilities long past the time of disposition. So that's one area that we've been pushing hard on and really encouraging states to improve their ability to collect and use guardianship data to do better guardianship monitoring. But we've also seen a lot of work done at the state level in terms of improving guardianship monitoring. A lot of this work has been done through the guardianship improvement grants, and we're really excited to see the progress that's happened. One of the areas is through, again, improved guardianship reporting. Again, Pennsylvania has been a real leader in this with your guardianship tracking system, but more states are building portals that will allow guardians to make reports through more of an interview process, more of a plain language process that will make it more accessible, especially for those family guardians, which we know are the majority of guardians. Not only are states working on those structured interview processes, but also increasingly using software that allows the automatic importation of accounting data from financial institutions so that people don't have to submit those detailed accounting reports. Not so much detail is required because the court is getting information directly from the financial institution. That, of course, also allows for more consistent monitoring of that, or more quick response if a problem is suspected, rather than just waiting for that annual accounting to come in. So that's something we see happening that is really, really exciting. We've also seen greater attention to guardianship alternatives, and that is really looking for less restrictive alternatives to guardianship and ensuring that we reserve guardianships for those cases in which they are absolutely necessary. This is really important from a civil rights perspective. We shouldn't be taking away people's rights if there are less restrictive alternatives available. It's also a workload issue for courts. All courts have limited resources. and we need to make sure that those resources are placed where they're most needed. And so those are reasons both from the individual side, but also from the court side, to make sure that we're limiting guardianships just to those people who truly need them. One of the exciting tools that we've seen developed in the last couple of years is Maryland's Ideal Guide. You're going to be hearing more about that during the conference, but it's a guide that was developed and came out of conversations with a lot of healthcare providers and a lot of guardianship partners to really help people who don't work in the court system think through alternatives to guardianship before they come to court with a petition for guardianship. Again, the goal there is to make sure that individuals are only getting guardianships in situations where there is no less restrictive alternative, and that's something that's really important. I've mentioned the need for guardianship monitoring already. A couple of different things that we've seen happening with that. In a couple of states, we've seen more centralized guardianship monitoring. And so sometimes that first blush of guardianship review is being done more on a central level. Minnesota is a state that's been doing this for a good while. Massachusetts also recently moved to doing initial review of well-being reports at their central office. The intention there is to remove some of that work from local courts that may really struggle with it, provide more expertise in that, and again make sure that judges are paying attention to the cases that most need their attention. So that is something that we see happening in a few places. What we see happening even more often is the use of monitoring protocols. I will tell you that a few years ago, when I would ask, doing interviews, talking to people working at local courts, and I would ask what they were looking for when they looked at a guardianship report, and the answer was often nothing, or just their own experience. And their own experience can be fabulous, but sometimes when you have turnover, a new person comes in, that's not really enough. And so we've created, again, with the expertise of partners around the country, including from Pennsylvania, guardianship monitoring protocols, both for the well-being report and also for the accounting. And this gives judicial officers or court staff or clerk staff a document to go by to help them identify what they should be looking for in those reports. And those are all available on our website, and you'll be getting a link to that. We strongly encourage the states to take a look at those and then adapt them for your own local needs. So the themes that we really see are the need for improved data collection so that courts can identify those who they should be monitoring, make sure that monitoring is up to date. We've seen improved actual monitoring processes in terms of making it easier for guardians to report. And we've seen a lot of movement towards making sure people are aware and are really pushing for less restrictive alternatives to guardianship. So Pennsylvania has been a great partner in this work, and we really value and admire the work that the Commonwealth of Pennsylvania has done. So appreciate your time today. I'm sorry that I couldn't be with you in person, but appreciate the opportunity to be part of this important meeting.
One of the ways that we keep learning is from collaborating with partners across the nation, partners in other states, and partners like Dr. Robinson. We're learning what other states are doing and keep trying to push that frontier forward so we stay on the cutting edge here in Pennsylvania. I'm privileged and pleased to welcome today two other partners. First, starting with Shannon Butler from Minnesota. Shannon has 20 years of experience as a guardian and conservator, is a current board member of the Center for Guardianship Certification, and an immediate past president of the National Guardian Association, and a certified National Master Guardian. So Shannon, welcome. Thank you for being with us today.
Thank you for having me. Is this working? Can you hear me? Okay. I'm going to wear two hats today. I'm a member, or I should say a board member of the Center for Guardianship Certification, as well as the National Guardianship Association. So I'm going to talk a little bit about both organizations. I appreciated hearing all the information today. I really feel like Pennsylvania is on the right track. In a lot of ways, it sounds like you're really tackling some of the big issues. So appreciate hearing what all you're doing. So as part of CGC, I wanted to welcome you as our 10th state that requires certification through the CGC. Currently, the states that require certification are Alaska, California, which is a hybrid, I will talk about a little bit later, Illinois, Nevada, New Hampshire, New Mexico, North Dakota, Oregon, Pennsylvania, and Utah. There are other states that require some form of certification or training. Just going to briefly touch on some of the ones that kind of stand out to me. The state of Washington, they probably have the most thorough guardianship program in the country, I would say, as far as what they require. They have mandatory 90 hours of training for professional guardians in order to serve in that state. They used to be using the CGC certification as well, but I believe they've developed their own certification process now. Texas kind of does their own thing. They had their own certification. I don't believe that, I'm not sure if they do right now. Sally, do they still require certification? Do you know? Texas? No, they're not requiring. They used to have their own. They don't require it anymore. I'm going to rely on Sally here. She's my guru to go to. North Dakota is a little different. I did a talk with them last year, and what I found interesting about their system is that they have a per diem system for paying for their guardians. So it's a statewide system. Depending on how that client is rated for difficulty or where they're living, they get paid per day based on that client's difficulty, which I thought was very interesting. Illinois, they are all appointed by the governor as public guardians in the state of Illinois. Missouri, they are guardians in Missouri, are elected officials. So that one's a little different as well. I'm just trying to give you kind of a sense of the different things going on out there in the country. Like she said, my whole philosophy is don't reinvent the wheel. Let's learn from other states what they're doing, what states are doing things well, what states could learn from us. Florida has their own certification. They require 40 hours of pre-licensing education. California, like I said, is a hybrid. They partner with CGC, so part of their certification is through CGC, and as well as they have their own state-specific certification that they have to do as well. I'll talk about Minnesota a little bit. There's things at Minnesota, that's where I'm from. Some things we do well, some things not so well. I think we have the My Minnesota Guardian, My Minnesota Conservator, which sounds a lot like your tracking system as far as data collection and tracking guardianships and ensuring the audits of the estates. Some of the things a couple of things I'm going to point out from Minnesota that I think some of them are similar, but I wanted to just share with you for Pennsylvania. Recently, I believe it was this past fall, we've totally redone our petitioning system for guardianship. It is now a 26-page petition in order to get guardianship. It goes through specifically all alternatives to guardianship, and you have to explain what you have tried, for how long, why it did not work. So we go through power of attorney, healthcare, technology resources, various things. So you have to explain when you do your petition, what have you tried? I think it's a great way. When I have to fill out the petitions myself, I don't enjoy it because it's a lot of work to do that, but it's very thorough. And it really, for judges that don't understand the whole concept of alternative, I think it's a great way to make them pay attention of what else have you tried. We also have a recent law in Minnesota for any guardianship that starts at age 18 or under age 30, it needs to be reviewed thoroughly with a full court hearing every 6 years. so that you can't slap a guardianship on an 18-year-old and that's on there for life. They have to have a full review, which I think is awesome. I've seen so many people, I always say your brain doesn't fully develop till about age 25, 26. There's a lot of them that from age 18 to there, they've gained those skills. And so let's work on getting those skills so they can get off of guardianship. There are several other states currently looking at certification requirements. Indiana, Michigan, Minnesota, Missouri, New York, North Carolina, and Ohio. We are hoping that we'll get more and more states on board with certification. Certification to me is not just taking that test and proving you can answer some questions. It is also the fact that you are saying, I will follow the standards of practice and ethical principles involved with guardianship. And that's what's important. Along with the fact that if you are not following those, there is a process that can be gone through with the CGC to get remedies for people that are not following those standards of practice. I'm going to switch over to my NGA hat now. So some of the things with NGA that we've been working on. As president last year, one of my big initiatives was data collection. As you're hearing over and over again, data collection is very important to get a picture of what's going on for funding, reimbursements, all kinds of things. As you spoke to, it was really nice to hear all the data that you're able to pull out of your system. We're trying to work on that on a national level. So what we have come up with so far with the NGA, we do have a data collection committee. This past year, we worked really hard. We realized we were taking on a lot when we tried to say, well, let's collect data for guardianship. That was way too much for us to try to bite off on. What we came up with was we do have a guardianship statement on data collection that's available on our website, saying these are the standards, these are the things you should be collecting for guardianship for all states, and so that we can be comparing apples to apples. Before we didn't have that. We've got various different types of information. We're trying to collect the same information. So that was last year, we completed that statement. That's online on the NGA website. The next part of that is we also wanted to be kind of the holder of guardianship data. So we are also trying to create, be kind of the holder of that guardianship data and update that regularly. So there is going to be like a data collection system in place that we're working on, so that when you're looking for guardianship data on Pennsylvania, you can not only, you can go to Pennsylvania or you can go to NGA. If you're looking for something on Minnesota, you can find Minnesota, those kind of things. So you get a better overall picture of what is going on with guardianship. Some of the other things we're working on were, if you're if you're not aware, we have a leadership training we've started this year. So we're hoping to bring up new leaders in the guardianship field. So if anybody's interested in NGA, there's a new leadership training program going on, and that'll be yearly. I see I'm running out of time here. I'm trying to go quick. We also have a new Guardianship 101 training that's in the process of being formed. That's going to be like an 18-hour class, probably online. And well, I'm trying to go quickly. Oh, I just wanted to say too, we also have NGA affiliates. Pennsylvania was kind of a unique situation where you didn't have an affiliate organization here in Pennsylvania for guardians. NGA came in and we helped develop a guardianship network for Pennsylvania. So if you're not aware, there is a guardianship network associated with NGA. You do have to be an NGA member to be involved in that, but there is a network that we've helped kind of foster along. My last little plug, and I'll get off the stage, is we're doing a lot of great things. My last thing would be, please advocate for sufficient wages for guardians. I think that is our next big hurdle. It's not an easy job that we do, and I just feel like we need to be treated as the professionals that we are and adequately reimbursed. Thank you so much.
Thank you very much, Shannon. And finally, I'm really pleased to introduce to you Erica Costello. Erica is the director of the American Bar Association's Commission on Law and Aging. In your materials in HUVA, it says she's the associate director. That's her previous job. She's now the director of the Commission on Law and Aging. For those of you who don't know, the Commission on Law and Aging is a leading resource for information about not only guardianship, but lots of issues that affect older adults across America, particularly in the law, and including advanced planning, really cutting edge resources and materials that guide a lot of our work. So welcome, Erica.
Hi, Pennsylvania. So good to be here today. Before I begin, I want to just offer you guys a round of applause for everybody here because you guys have done such great work with guardianship reform. I have been really impressed. Every year I do a review of legislation across the country, and every year I see the things that Pennsylvania has been doing, in particular with guardianship reform. It's been highlighted throughout all of the sessions I've seen this afternoon, and especially with less restrictive alternatives. So I just want to let you guys know that you guys are really leading the way in this country. I do oftentimes spotlight Pennsylvania in a lot of the sessions I talk about and the ways that you guys have been moving the needle, in particular with guardianship reform. So again, thank you guys for doing that. I'm just trying to see how I'm, let me see if I can get the clicker, I guess. Yeah, thank you. No problem. Okay, so let's talk a little bit about some of the national trends that we have going on, in particular with guardianship reform. So the things that I'm going to specifically highlight are supported decision-making and the states that have legislated supported decision-making. Going over also the National Guardianship Bill of Rights, as well as the Uniform Guardianship, Conservatorship, and Other Protected Proceedings Act, or Protective Arrangements Act. So first of all, I kind of want to start with the supported decision-making. I know that Pennsylvania has really targeted less restrictive alternatives, but really the next step would be codifying supported decision-making in this state. We have now half of the country that has codified supported decision-making either as the concept of supported decision-making and or supported decision-making agreements. This really should be the next thing that you should look at as identifying and targeting here in Pennsylvania. So what are we looking at with supported decision-making? Really, it's looking at making decisions and using individuals or having individuals assisting people in making those decisions, or basically the way that we all make complicated decisions. It's something that you and I do every day. I wouldn't be making complicated decisions without consulting people in my life, whether that be family members, whether that be friends, whether that be other professionals that I'm working with. And so really, again, this is something that we are all doing on an informal basis. But what's really particularly important about the reasons why you want to look at codifying this is really because of that third-party recognition. So we'll be getting to that in a second. Again, I want to kind of highlight some of the things that other states are doing. We have 19 states that have full decision-making agreements, at least in this country. These are just from 2023. I'm actually going to be going through updates this summer from 2023 to currently. And of those states, 6 states use the term principal. It's probably not the best idea because it does get a little bit confusing for people, specifically in the legal practice. It echoes power of attorney language, and when you're trying to make that distinction between a power of attorney document and a supported decision-making agreement, that gets a little bit challenging for people. So again, when you're looking at supported decision-making agreements, you might want to look at other language. Of the 19 states with supported decision-making agreements, only Illinois limits it to adults or persons with intellectual disabilities. So again, very broad coverage. I just came back from an aging conference. We have a lot of work to be doing in that area because supporting decision-making agreements can cover that population as well. So most of the states allow adults with disabilities or simply adults in general to use these agreements to assist them in making, again, their decisions. Again, I go back to the fact that more than half of the country now, and I think we're up to a total of 29 states that now have legislation with respect to supported decision-making in this country as a viable alternative to guardianship. Reporting of abuse. At least 15 states restrict who can be a supporter if there's a history of abuse, neglect, or exploitation, or if there's restraining orders involved. There's also provisions within the statute to terminate agreements if there's a history of abuse by the supporter, or if the supporter is abusive in any capacity. And then there's also, in a lot of these legislative provisions, third parties who have to, again, report suspected abuse if there is concerns about abuse, neglect, or exploitation to adult protective services and or law enforcement. So things to consider, again, if you're looking at supported decision-making legislation. Enforcement. Here is, again, why it's really important to look at codifying supported decision-making. It's for third-party recognition. Why is that important? Because most states permit third parties to rely on those supported decision-making agreements. So it's hospitals, banks, group homes, residential settings, those entities that can now rely on those documents when they're looking at having who's at that table for those care plan meetings, who's going to be involved in those discussions. And it also limits the liability of the third parties who rely on those agreements. Access to information. Again, statutes that allow supporters to have access to those information under those agreements. And then most states specifically or explicitly require supporters to keep information confidential. So things, again, to consider with those statutes. All right, now I want to talk a little bit more about some of the things to consider with supported decision-making. I know that, again, we're running short on time. So there's a lot of different individuals who can be involved as supporters. It can include professionals. It can include family members. So we're looking at social workers, case managers, sometimes individuals. It can be attorneys. Attorneys can be supporters. If the person cannot pay, you have to look sometimes through in the community. We're really looking at person-centered planning. These should be, again, for those people who are guardians, this should very much fit within the construct of guardianship, right? Because principles of guardianship, you're looking at person-centered planning and going along with what that person wants. So we're looking at trying to see who could be generating a list to see who can serve as supporters. Oftentimes it could be anybody who's within that individual circle, family, friends, neighbors, trusted professionals, trusted service providers, anybody who they frequently interact with. Think outside the box. Again, when there seems to be nobody, try to look a little bit further. Do they have any regular contact with anybody? Are there anybody that they trust? Distant family members? Sometimes, though, just consider the fact that there may be some negative history and honor their wishes if there isn't a desire to have contact with them. All right, let's talk a little bit about Guardianship Bill of Rights. I see some people here who have been highly involved in this. Fourth National Guardianship Summit in 2021 came up with Guardianship Bill of Rights. It was one of the 22 recommendations that was made. And really, we're looking at several different types of rights, either retained, removed, or delegated. This is really important because it's really codifying rights for individuals under guardianship. And I think some states already do this, but again, we're looking at states to look at their statutes and implementing these laws within their statutes if they don't already have them. Access to justice rights are particularly important when you're looking at right to counsel, right to be present at the hearing, right to have the court know your concerns and complaints about guardianship. So again, these are all things that sometimes states already have codified, but if they haven't, they need to look at whether this is something that they should be looking at putting specifically and explicitly within the statutes. Core human rights. These are things, again, that sometimes states have not really explicitly put within the statutes, but it's something they should look at including if they haven't already. The right to be treated with dignity and respect. the right to be free from financial exploitation, abuse, neglect, the right to remain as independent as they can. Again, these are things to consider if they haven't. And then again, some of the decision-making rights. And so the one thing to consider about the Guardianship Bill of Rights is that, again, we have states that have already kind of looked at codifying this. The most recent one was actually New Mexico. New Mexico just did this within the past month. They did it through judicial rule. So you can look at doing this sometimes through judicial rule, or you can sometimes do this through the legislature. But it's something to look at putting explicitly within your law, so that, again, it's giving rights to respondents pursuant to guardianship, either pre-petition, post-petition. ACOPA. Anybody here has anybody here heard of the Uniform Guardianship Act at all? Yeah, hopefully. Okay, some people. This is, we're on the 4th generation of the Uniform Guardianship Law. And good news, we have now added Kansas to the list this last year, just within the last, earlier this year. It's been adopted in full by Maine, Washington, and like I said, Kansas just added to the list. It was also introduced in Colorado and Idaho this year, and it's adopted in part by at least 5 other states, although several states have already adopted either the 2nd or 3rd generation of it. What's important about the provisions of the Uniform Guardianship Act is that it does have, again, very person-centered guardianship plans and provisions that allow for periodic monitoring and compliance measures, enhanced notice to parties. Many, again, of some of the provisions that you already have looked at in Pennsylvania if you haven't already implemented it. But it also kind of looks at these alternatives to full guardianship, including supported decision-making, and having to look at ways that we can protect individuals under guardianship from isolation from family and friends, as well as making sure that guardians have standards that they have to look up to and expectations as well. So those are just some of the things I wanted to spotlight and highlight. I know we're right at time, so I don't want to keep you because it is your first day, and it's hard sometimes to start presentations on time. But I'll go ahead and turn it back over to Judge Murphy. So thank you so much. Let me know if you have questions.
Thank you, Erica. That was excellent and gave us lots to talk about and think about other things we can do as we move forward.